everyone. Happy Monday morning. This is Carol Williams with Williams Immigration, and we are back with Beyond the Soundbite, where every Monday morning we talk about what's hot and what's happened in immigration the week before. So this week is no different. We've got quite a few things I want to talk to y'all about. And today we're going to talk about the H-1B rules and what's going on there. We're going to talk a little bit about the K-1 Fianc Visa, and we're also going to talk about some good news going on for our dreamers in DACA. So let's dive right in. Again, I'm Carol Williams with Williams Immigration, and this is Beyond the Soundbite. So this morning I want to start off up with the H-1B. There's been a ton of movement this past week. So for those of you that don't know, the H-1B is an employment-based visa category. It is what I like to refer to as the workhorse of the employment categories. It is used by all types of different industries, whether you're in tech, whether you're in biomedical, whether you're in manufacturing. The H-1B is used by just about everybody. It's a highly sought after visa category. In order to qualify, the job must require a bachelor's degree at a very minimum, and the individual needs to have a bachelor's degree in a related field. This H-1B is used by quite a few companies, and quite a few of our international students transition from their student status over to H-1B when they find their first job out of university here in the US. So it's a highly sought after visa category, and there's a limit on the number that we have every fiscal year. There's only 85,000 issued every fiscal year. So it's not an unlimited visa category. But let's hop into these rules now that I've given you just a teeny bit of background on the visa category. So for H-1Bs, back in October, we had two rules that came out. We had one rule issued by the Department of Labor, and we had another rule issued by DHS/USCIS, the Immigration Service. The Department of Labor rule changed the prevailing wages and increased them significantly, and quite literally did it overnight. The rule was effective on the day it was published. So the day it hit, boom, it was automatically effective. So that made it extremely difficult for employers who were using and planning and using the, at that point, current prevailing wages that we use that come out from the Department of Labor. So quite literally overnight, those prevailing wages changed. We had no opportunity for notice and comment. We had no opportunity to write into the government and say, hey, here's what we think about these rules. It was just automatically implemented. The second rule that came out back in October, which oddly enough was supposed to be effective today, was from the Immigration Service. And that rule essentially was looking to change, again, significant changes into how positions are classified, whether or not they are considered specialized knowledge, and whether or not they are considered to require at a minimum a bachelor's degree. So again, that rule came out super fast. They wanted to implement it extremely fast. They did not give sort of the usual 30-day hold on implementation. In fact, again, the comments for that rule were due a while ago, and it was supposed to be effective today. So the immigration, so litigators went to court and said, hey, what's happening here? Well, the reason behind both of those rules provided by the government, provided by both agencies, was that because of COVID-19, this was an emergency situation, and the White House administration, through the agencies, really wanted to help U.S. workers and preserve those jobs for U.S. workers. And so it's wound its way through the court system. And the judge essentially said, while we understand what you're trying to do, we don't find that this situation to be emergent enough to stop the process of notice and comment, to stop the process of giving interested individuals the opportunity to provide their comments and their thoughts on the rule, and then to actually have the government come back and respond to those comments. So as of last week, these rules were stopped in their tracks. These rules are currently no longer in play. But what does that mean for you all, for the employers, for the employees? Well, right now, because the rules are no longer in play, the government may choose to appeal the judge's decision. So we may see these rules come back. The government may choose to quickly republish these rules, allowing for an extensive notice and comment period. So those are kind of two options on the table for the government. What we see as a practical matter is we now need to wait for the Department of Labor to allow us to reset the wages back to what they were before the new rule was in place. They need to allow us to now file our labor condition applications under the old prevailing wages. So we've been told that as of December 9, let me look at my notes. As of December 9, beginning roughly around 8:30 in the morning, we should be able to do that. We'll see if that actually happens. And they've said that there may be a few hiccups in the system. So it's based on technology, so there may be some hiccups. So we just got to kind of ride this roller coaster a little bit further and a little bit longer, it would seem. And this is all before the H-1B season starts to heat up. So if it continues like this, H-1B season will either be a hot mess or it'll be really boring. So hopefully we will get all of this worked out before H-1B season really starts to heat up, and H-1B season is super boring and goes off without a hitch. That is my wish. So I'm going to put that out into the atmosphere, that H-1B season is just super easy, super boring, nothing really interesting happens. That's my wish. So the next thing we want to talk about today is the Department of Labor rule impacted more than the H-1Bs. So that those prevailing wages that they changed overnight also impact green card applications. They impact those green card applications where an employer must advertise for the position and essentially ask and request from the Department of Labor a prevailing wage. So we're also now going to see perhaps a few hiccups with those prevailing wages that now need to be redone using the now old before the rule, using those wage numbers as opposed to those that were issued from October until today. So lots of things that are happening in H-1B world. Those also impact the green card applications. But just in case you thought we were completely done talking about H-1Bs this morning, we are not. So still alive, still very much in play. The White House is trying to change the way that the H-1B lottery applicants are chosen. They are winners in the H-1B lottery. Last fiscal year, we saw where the administration changed the way that lottery applications are chosen to more heavily weight those individuals who were applying that had a master's degree from a U.S. university. Now, the administration would like to more heavily weight and have a bigger chance of getting selected in the H-1B lottery for those applications that have a higher wage for those positions. So that rule has been published. Notice and comment period end today, I believe. So that rule is still in play. So we're still now watching where that rule goes and what happens with it. Of course, I will be watching that, seeing what happens. Here's the thing though. we know that the White House will change hands in January. So not quite sure if the current administration will be able to push this rule through prior to that happening. Just not quite sure if we've got enough days on the calendar to make that happen. When a new rule comes out, we should be given a chance to provide notice, or we're given notice, we should be given a chance to provide comment on that rule. It's my understanding that many people wrote in comments. So the government now is under the obligation and has the responsibility to read through all of those comments and take them all into consideration when thinking about whether or not they want to tweak the rule based on the comments. Then they've got to publish a final rule. There's a whole process that happens in the federal government. So again, I'm just not quite sure that we have enough days on the calendar prior to the new administration coming in to get this rule in its final published form. So we'll see. We might be really pushing up against the wire there. So we'll see what happens there. So again, this is all happening right before H-1B season starts to heat up. So H-1B season could be a complete and utter hot mess, or it could be really boring. I, again, am voting for really, really boring. We've also seen some really great news for our dreamers out there. DACA has been fully reinstated. Federal judge ordered the Immigration Service to fully reinstate DACA for our dreamers. Our dreamers are individuals that are in this country who came over as children, and they were young children. They had no say in whether they came over. They've been living in the U.S. undocumented since they were, many of them since they were very young children. They've done well. They have gone to school. They don't have any criminal history. And so they have been, quite frankly, a political football to figure out, and they have been used, do we support DACA? Do we not support DACA? What sort of restrictions do we have on DACA? So the DACA program, has really been used, and the dreamers have been in this state of limbo as the rules kind of ping pong back and forth. DACA was signed under President Obama. Under the current White House administration, they have worked really hard to essentially stop DACA and to stop accepting new applications of DACA. But the federal judge recently ruled that DACA needs to be fully instated. So what does that mean? That means that USCIS now must accept not only new DACA applications, which it has not been accepting for quite some time, renewal DACA applications. So if you need to extend your DACA, they need to accept that. They also need to process advanced paroles, which are travel permission for individuals that receive DACA. And they need to update their website, letting people know that this is an available benefit that they can now apply for. So we will see when and if the website gets updated and whether or not the Immigration Service begins to fully satisfy the court's order and accept new DACA applications and continue to accept the renewal DACA applications, as well as issuing advanced parole for those that are qualified. So that was a great news for our dreamers and for DACA. Next up, I want to talk about the K-1 fiance visa. The K-1 fiance visas they've been really at a standstill at the overseas consulates. Federal court essentially said, hey, listen, we need y'all to kind of rethink how you're handling these. So they were not scheduling them. Now, I have seen on the Department of State website, they have issued guidance that they will begin scheduling visa appointments. So that's good news. Understand, even though they are scheduling appointments, you are not going to be put at the head of the line. So you're not going to bump everybody else who's also been waiting. So you'll be put in line just like everybody else. So they will start processing the fiance visa applications. That said, if you are coming from a country where there's currently a travel suspension, while the consulates will start processing the K-1 applications because of the various current White House proclamations restricting travel, even if the K-1 visa is approved and put in your passport, you still may be subject to a travel restriction. So it's very important to understand that even though you can now reach out to your consulate, start that process of requesting an application. If you requesting an interview, if you get the interview, understand that that doesn't mean that you can automatically fly to the US once you have been approved. We still have to look at whether or not your specific country is subject to any travel restrictions. But that is, in very typical immigration ways, one step forward, which I think is great, and I'm going to accept that for my clients that are waiting overseas. So one step forward. The last thing I want to talk to you all about is the border between Canada and the US and Mexico and the US. It has been essentially, the land border has essentially been closed to all non-essential, non-work related travel since March because of the pandemic. And it will remain closed. They look every 30-ish days. The governments get together, they powwow, they have a conversation, and they have decided to keep the border closed until December 21st. So will it go into January? Probably. We don't have anything official just quite yet. But as of right now, December 21st is the day that, they will reconvene sort of slightly prior to that and have a conversation. So that is what's hot and what's happening in U.S. immigration as of last week. Lots going on with the H-1B visa. K-1 fiancé visas have seen one step forward. And we've got some really great news for our dreamers out there who are looking to apply for DACA for the first time, and those who are looking to renew and potentially apply for travel permission in the form of advanced parole. So if you have any questions for me, please feel free to drop those in the comments. If you have found this helpful, click like and click share with anyone that you think may also find it helpful. And I am super happy to be here with y'all on another Monday. I will see you next Monday with Beyond the Soundbite, and I am Carol Williams with Williams Immigration. Have a great week, everybody.